Good morning, everyone. This is the September 19th edition of the Tesoro broadcast. We're going to go back and visit and Richard B. Sanders in a few minutes. I'd like to remind everybody that we are giving away a 2.5 pound rock that is, it's got gold in it, it's got fool's gold, and fool's gold has gold in it as well. You just have to get it out a little differently than you would if you were going to just process for normal everyday gold. But it is a pretty rock, and we have pictures of it up on the website, and all you need to do is send us your name, email address. We will add you to our mailing list, and you will have the chance to win this 2.5 pound rock during the week of Thanksgiving, and we will get it to you by Thanksgiving. So anyway, to get onto this thing, Richard B. Sanders is a guy that is a friend of Gordon Walters, and Richard B. Sanders for Gordon was threatening me with emails and everything else, and then he went and did something really stupid which caused him to be placed under arrest in federal custody on February 1st of 2010. He wrote a letter to a United States magistrate, and I'm going to read that letter to you at this moment, and then we will give you the judge's opinion next week. It was addressed to Carolyn Ostby, O-S-T-B-Y, U.S. Magistrate, United States Federal Courthouse, North 26th Street, Billings, Montana, 59101. It says, Dear Judge Ostby, on March 26, 2010, you had me before you on a bail hearing. You appointed me a Billings federal defender who did not want to consult with me before the hearing. In fact, all he wanted to be was a professional plea bargainer, not a lawyer, so the whole matter could be slam dunked for the prosecution. I had witnesses present in the courtroom, but he wouldn't call them. Then you heard from a deputy, Sean Lisnick, a corrupt officer of the Muleshoe County Sheriff's Office. A tape was played, but not the whole tape, and bingo, no freedom for me. I was labeled by you that I was a danger to the community. You insisted that I had been convicted of 4 felony convictions, and I was in possession of multiple firearms. The time has now come for you to rethink these statements based upon the following information. My present attorney has placed before you a motion for a rehearing, and I am on a status crime. There is no victim. I somewhat disagree. I am the victim, and you and Brian Whittaker and the Office of the U.S. Attorney have become a perpetrator. How is this possible, you wonder? Well, first, let's take a look at the facts. I am not a felon in possession of a firearm and ammunition under 18 U.S.C. 921 subsection A, subsection 20. How is this possible when I was convicted in 1981, 29 years ago, in the Billings Federal District Court, a felon in possession of a firearm? I have previously told you that my rights were restored by the state of Montana under the Montana State Constitution, Article 2, Section 28-2, and statutes pertaining to the rights restoration. I also told you that a treaty exists known as the Compact of 1889 guaranteeing rights restoration as a precondition of Montana statehood. There is also the 14th Amendment to the Constitution. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of states in which they reside, and the citizens of each state shall be entitled to all privileges and immunities and citizens of the several states. This is called dual citizenship of the 14th Amendment, a federal constitutional guarantee. Article 4, Section 2 also bestows dual citizenship upon me and others. By virtue of a personal citizenship in a particular state, he was guaranteed whatever rights and liberties that a state's constitution and laws made available. The assurances that would be afforded the privileges and immunities of citizenship in any of the several states in the Union to which they might travel. See McDonald versus Chicago, October term 2009, U.S. Supreme Court. See page 3 of the Thomas opinion. See also page 12 of Alito's opinion. Now see page 30 of Alito, especially footnote 27, mentioning Montana Constitution 1889, Article 3, Section 13, also page 7, Alito opinion to the court, footnote number 5. Being thus said in the above, anything constitutional, either statute, act, or condition that violates the Constitution is void. Mayberry v. Madison, 1803. The very act that repealed the provisions of Egressor 788 F2D 140, parentheses 9CA, however, enacted the current vision of 18 U.S.C. 921, subsection A, subsection 20, See Firearm Owners Protection Act, and with its references to the law of the jurisdiction where the predicate conviction occurred, quite clearly does contemplate that the federal firearm statute will be applied in patchwork fashion with enforcement dependent upon the law of the state in which the predicate conviction occurred. In light of this change in the law and our subsequent decision in Gomez, the government's reliance on aggression is not well taken. Furthermore, in 1981, they used 18 U.S.C. 1202, subsection A to convict. The statute was repealed by the FOPA in 1986, and Dickerson versus New Banner Institute was also set aside by the FOPA. Brian Whitaker has also quashed a subpoena involving a witness in violation of my Sixth Amendment rights. I hope I'm getting through to you. I hope you are learned in law and a student of the Constitution of the United States. So far, my civil rights have been trampled. I've been thrown in jail and have suffered irreparable harm. I've been chained, shackled, and gassed. Thrown in solitary confinement because I demanded medication for my blood pressure pills. I've been dumped in a state prison in Shelby that denied my rights as a 70-year-old man with back problems when I couldn't climb into a top bunk. I was thrown into a segregation unit, SMU, for 4 days. I've been transported in a black box by Shelby Transport Unit to and from Billings numerous times in a condition of nausea, without restroom stops, no water, no food, all because of status of being a felon in possession. All this based on the corrupt Deputy Sheriff Lisnick, who hoodwinked you in believing I am a threat. My civil rights have been discarded and trampled under federal and state constitutional law and have been denied any kind of bail. My status has been in lockup for over 7 months, and as a result of actions taken by you and Brian Whitaker, my family has suffered irreparably. I say nothing more except release me at once. Note, Shelby is a private state prison that operates for profit and routinely abuses prisoners' rights, especially the non-convicted, under color of law. USMS uses the prison to house federal detainees without regard to consequences suffered. This includes, but not limited to, legal mail, client attorney privacy, age, infirmary, mental, physical condition, and rules imposed by the DOC Montana State Prison, which should not apply to federal prisoners. I was gassed because of something that happened in another pod when guards placed tear gas in the air conditioning system, and it spread through the air ducts into another pod, causing hours of not being able to breathe. Black box transportation in full shackles and cuffs is another way of torturing prisoners to bring guilty due to lengthy stays in confinement and transportation. No water, no food, or rest stops. This is a letter that was written to the judge by Richard Sanders. The laws are clear that if you're convicted of a state crime, then the governor of the state has the right to pardon you and give you back your constitutional rights. But if you've been convicted of a federal crime, the only person that can pardon you and give you back your constitutional rights is the President of the United States. And Richard Sanders is a person who, under Ryan North 22 on Twitter, hates the President of the United States, would love to overthrow the government. So that's it for this week. We will go over the judge's comments next week, and I'll be seeing you then. Thanks very much.